Hello, this course is about the Law Society of British Columbia's anti-money laundering measures to regulate BC lawyers and to protect the public from wrongdoing. Barbara Buchanan, KC, and I are presenting this course today. My name is Tina Kaminski, and I am an audit team leader at the Law Society of BC. BC lawyers can apply to the Law Society for CPD credit in the area of professional responsibility and ethics and practice management. I am also a chartered professional accountant, certified fraud examiner, and a certified anti-money laundering specialist. I have over 15 years of internal audit experience in the regulatory field and over 5 years of public practice experience in one of the Big Four accounting firms. I use my expertise to collaborate with the other law societies in Canada to exchange information on auditing techniques to detect money laundering. Joining me today is Law Society Practice Advisor Barbara Buchanan, KC. Barbara has been a frequent presenter and educator regarding the Law Society of BC's anti-money laundering rules and related topics for the CLEBC, the CBA, law enforcement, the BC Legal Management Association, and others. Through her role at the Law Society, she provides confidential one-on-one advice to lawyers regarding anti-money laundering, client identification and verification, fraud, and scams. She also provides support to the Federation of Law Societies of Canada with respect to the Model Rule on client identification and verification regarding education and issues of concern. She was called to the bar in 1988 and outside of the Law Society has worked in private practice as general counsel of an international company, as an adjudicator, and as an educator in Canada and abroad. As part of the Law Society's ongoing commitment to provide up-to-date guidance on anti-money laundering, the Law Society is making this program available and easily accessible to all lawyers and their staff. The course is useful for new lawyers who may not be completely comfortable with their obligations, but the course is also helpful for more seasoned individuals who could use a reminder to ensure compliance is being maintained. While money laundering can occur in many professions or organizations, our focus is on lawyers and their trust accounts. For over 2 decades, the Law Society of BC has introduced many initiatives to ensure lawyers do not help anyone to act contrary to the law. As part of the initiatives, rules were added to the BC Code and the Law Society rules that relate to cash, client identification and verification, use of the trust account, and a lawyer's overall responsibility to not involve themselves with anything illegal. In today's presentation, Barbara and I will review what money laundering is, risks to lawyers, red flags, and 3 of the Law Society's anti-money laundering measures: trust account rules, the cash rules, and the client identification and verification rules. We will also touch upon some relevant BC Code rules. At the end of our presentation, we will be providing resources. All of the resources are free and easy to access. Assuming you follow the news and read Law Society publications, you will know the term money laundering. There are 2 well-known reports by Dr. Peter German, KC, on money laundering in BC. The first report was called Dirty Money and focused on casinos. The second report, called Dirty Money Part 2, focused on luxury cars, real estate, and horse racing. There was also the Experts Panel's report, Combating Money Laundering in BC Real Estate, chaired by Professor Maureen Maloney. Furthermore, there was the June 2022 final report of the Commission of Inquiry into Money Laundering in BC by the Honorable Austin F. Cullen, Commissioner. The Commissioner found that while it wasn't possible to put a precise figure on the volume of illicit funds laundered through the BC economy each year, the available evidence showed that the figure was very large, with some estimates in the billions of dollars per year in BC alone. Since this presentation is about measures to combat money laundering, we need to first define money laundering. So what is money laundering, and why do we care? There is no one single definition of money laundering. Simply put, money laundering is a process where criminals take money gained from criminal activity to make it safely usable. Along the way, they will need to disguise the fact that the dirty money was derived from criminal activity. That's where the concept of cleaning or laundering the money comes in, making the money appear to have come from a legitimate source. The dirty money may have been made in a myriad of ways, including bribes for college admissions, stock manipulation, tax evasion, fraud, wildlife trafficking, human trafficking, and illegal drug trafficking. Lawyers face an inherent risk of being used knowingly or unknowingly to facilitate money laundering. The Law Society, as a regulator of lawyers, plays an active role to minimize risks. The Law Society establishes rules and standards for the education, profession responsibility, and competence of lawyers. 2, has significant audit and investigative powers and a comprehensive audit program. 3, has teams of auditors, forensic accountants, forensic analysts, and investigators and takes disciplinary action. And lastly, has practice advisors and free online resources to assist lawyers to meet their professional obligations. What are lawyers' obligations? Lawyers must comply with their professional responsibility obligations in the Legal Profession Act, the Law Society rules, and the Code of Professional Conduct for British Columbia, including the canons of legal ethics. A lawyer owes a duty to the state to maintain the law and not to aid, counsel, or assist any person to act contrary to the law. Why do criminals want to use lawyers? Lawyers are attractive to criminals for a number of reasons. Here are some examples. A lawyer may make transactions look legitimate. Lawyers are respected professionals and enjoy a high level of trust. By using a lawyer, the criminal tries to hide behind that trust as well. Secondly, criminals want to take advantage of solicitors' common services. By nature of their profession, solicitors routinely facilitate transactions that may lend themselves to unwittingly assist criminals in creating complex transactions or business structures. They create companies and trusts, facilitate real estate conveyances, loans, and the purchase and sale of securities and other assets. Criminals also want to take advantage of litigators' common services. Criminals sometimes pursue fake loans, phony builders' liens, and other claims. Criminals try to obtain solicitor-client privilege with respect to their transactions to hide the illegal nature of their transactions. Generally, lawyers must keep their client's information confidential and maintain the client's privilege. However, lawyers cannot assist a client to do something that is dishonest or illegal. Lastly, criminals will seek to use a lawyer's trust account to facilitate the movement of funds and minimize the detection of wrongdoers. Money laundering is a process that criminals use to disguise the source of money or assets derived from criminal activity. Money laundering can occur without cash being involved. However, we have often associated with cash. Traditionally, money laundering has typically been described as involving 3 stages. Here's a diagram that visually summarizes the money laundering cycle. The first step is placement. The criminal has to get the cash into the financial system. This is typically the hardest step, as all intermediaries within the financial system have strict handling rules and reporting requirements over cash. Criminals cannot walk into a bank and deposit $1 million cash without being questioned. Al Capone allegedly purchased laundromats to mix illegal profits from prostitution and bootleg liquor sales with legitimate laundromat revenue. Businesses like restaurants, casinos, and laundromats were cash-intensive businesses, so deposits of cash were not unusual. And of course, some criminals will try to deposit cash with lawyers. However, the Law Society has strict rules regarding cash, which we'll cover today. The second step is layering. Here, the criminal attempts to move the funds around within the financial system to make it more difficult to trace the source and ownership of funds. The third and final step is integration. Finally, the criminal can use the funds for purchases that will benefit themselves under a veil of legitimacy. Let's say we have a criminal named Ricky. Ricky is a drug dealer and sells carfentanil. Business is good, and Ricky made $100 million in cash from his customers. He currently keeps the cash in his basement, but he's concerned that his rivals will rob him. Ricky cannot walk the cash down to his local bank and deposit the money as the bank will question him. It is also difficult to use large amounts of cash without drawing attention to himself. So Ricky wants to somehow get that cash into the financial system. How can Ricky get the money into the financial system and make sure that the $100 million cannot be traced back to him? To do that, he may try to open multiple bank accounts and deposit smaller amounts at each bank. He may use banks in jurisdictions with weak money laundering controls or jurisdictions known for bribery and corruption. Once Ricky has placed the money into the financial system, he will want to layer the money by creating numerous complex transactions that are hard to trace by law enforcement. At this point, he may try to retain a lawyer for legal services, such as creating companies to engage in transactions. Once he has the lawyer's assistance, Ricky may use the money for legitimate purposes to benefit himself, such as buying real estate or a luxury car. At this point, the money that Ricky spends looks like a normal purchase. In this stage, referred to as integration, the criminal proceeds have been cleaned and appears legitimate. When money laundering is brought up in relation to BC or Canada, you may hear the expression, the Vancouver model of money laundering. Let's do a quick quiz to see if you can pick out the scenario that has been commonly described as the Vancouver model of money laundering. The first scenario involves the Vancouver Special, a popular house style that was built between 1965 and 1985. Bad actors purchase properties with illicit funds with the intent of selling the property for profit in a short period of time, estimated to contribute to the existing housing crisis in Vancouver. The second scenario involves straw buyers making purchases of luxury cars with illicit funds. The car is delivered to the actual owner, who subsequently sells it to someone offshore. Since cash purchases are not illegal, criminal proceeds may be laundered through the purchase and export of these vehicles. In addition, once the car is sent overseas, the straw buyer applies for a PST refund. The third scenario involves individuals requesting the use of shelf companies from lawyers. Although it isn't illegal to use a shelf company, using one can make a business appear that it has been in existence for years and can help criminals open bank accounts, hide illegal activities, and purchase property. The company's lawyer will usually also act as the company's registered and records office and maintain all corporate records, including the articles of incorporation, the Central Securities Register, and Transparency Register. The fourth scenario involves China limiting its citizens from withdrawing more than 50,000 out of the country at a time. To get around this dollar limitation, bad actors would meet wealthy Chinese individuals in Vancouver and provide them with hockey bags full of illicit cash made from drug sales, which was taken to casinos to be converted into casino chips. The Chinese individuals would then repay the loans to the bad actors with clean money by depositing the funds into bank accounts in China or Hong Kong. For fun, which scenario do you think is referred to as the Vancouver model of money laundering? While all four scenarios involve laundering illicit funds, the correct answer is number 4. Commissioner Cullen, in his final report, indicated that between the years 2008 and 2018, Lower Mainland casinos accepted hundreds of millions of dollars in cash that were proceeds of crime through what has now been referred to as the Vancouver model of money laundering. Before, we talked about Ricky, the drug dealer, placing cash into the financial system. Let's consider another example about how a lawyer might unwittingly help a criminal launder money. In the placement phase, a criminal might try to provide a lawyer with cash under the guise of a retainer for legal services and then request a trust check as a refund. The criminal will want to take that trust check and deposit the clean money into his own bank account. As we will discuss later, the Law Society has strict rules on how much cash a lawyer can accept and for what purpose. In the layering phase, a criminal might ask a lawyer to help him create loan agreements with offshore companies. The lawyer then receives a large amount of money from the client, which the lawyer is asked to send to a third party. Alternatively, a third party will send the lawyer a large amount of money and request that the lawyer send the money to the lawyer's client for the loan. The money received could be by way of bank draft, check, or wire transfer, since the cash rule limit is $7,500. Regardless, the criminal client never goes ahead with asking the lawyer to create the loan agreement. So legal services are not actually provided. The criminal is only interested in using the lawyer to facilitate the transfer of money between his domestic bank account and an offshore bank account, for example, for tax fraud or corporate bribes, in order to disguise the connection between the client and the third party. In the integration phase, a lawyer might engage a lawyer in the purchase of a $5.2 million property in West Vancouver with no financing. When the lawyer inquires about his client's occupation, the client simply says, "I am a businessman," and refuses to elaborate on what he actually does and explain the source of the purchase money. I'm not sure. I might have said in the integration phase, a lawyer might engage a lawyer. I meant to say a criminal might engage a lawyer in the purchase of property. BC gained a reputation for being a place to launder money, making it attractive to criminals. It's easy to distance yourself from caring about money laundering. The vast majority of us are law-abiding citizens and believe that the people we choose to surround ourselves with and clients that we deal with are not bad people. However, money laundering is not a victimless crime. Here are a few examples about why we should care about money laundering. Laundering illicit funds through real estate purchases and sales can inflate prices, making it less affordable for people who live and work here to purchase homes. Laundering illicit funds through front companies enables criminals to sell products at lower prices than legitimate businesses that may be unable to fairly compete. People are victimized by illegal drugs and human trafficking. BC wildlife is depleted by trafficking wildlife and animal parts, for example, trafficking in bear paws, eels, lobsters, and turtles. Criminals don't pay their fair share of taxes to support healthcare and other government programs and services. Lastly, profits from crime can be used for more criminal activity. There are several Law Society rules and BC Code rules related to anti-money laundering. They include the trust accounts only for legal services rule, the limits on cash rule, the client identification and verification rules, record keeping and retention requirements, and the BC Code rules. Barbara and I will go through a number of the rules in this course. In the second section, we will talk about the proper use of a trust account. Why do we refer to lawyers as gatekeepers? Because lawyers are gatekeepers to the use of their trust accounts. In April of 2018, the Law Society published a discipline advisory titled "Lawyers Are Gatekeepers." We highly recommend that anyone who deals with a trust account read the advisory. It explains that since transactions in a lawyer's trust account may be protected by solicitor-client privilege, lawyers need to ensure they are not allowing suspicious transactions to flow through them. Therefore, lawyers have a duty to make reasonable inquiries to satisfy themselves that their clients' transactions are legitimate. As the discipline advisory explains, where the circumstances of a proposed transaction are such that a lawyer should reasonably be suspicious that there are illegal activities involved under Canadian law or laws of other jurisdictions, it is professional misconduct to become involved until time until such time as inquiries satisfy the lawyer on an objective test that the transaction is legitimate. The Law Society need not prove illegality to prove a lawyer's misconduct. Now, let's turn our attention to some trust rules that relate to anti-money laundering. As noted earlier, funds held by a lawyer in a solicitor-client relationship may sometimes attract privilege. Funds held by lawyers outside the solicitor-client relationship do not attract the same privilege. Rule 3-58.1 therefore reiterates the need for lawyers to carefully determine why their trust account is being used. The key words you should pay attention to are funds to be deposited to or withdrawn from a trust account and directly related to legal services provided by the lawyer or law firm. Let me explain further. While you may be performing legal services, the funds for each transaction that flow in and out of trust must relate to legal services you or your firm is providing to a client. Don't allow money to be deposited to your trust account before you are retained to provide legal services, you know who your client is, and you are satisfied that the transaction for which you are retained is legitimate. Subrule 2 of Rule 3-58.1 requires lawyers to take reasonable steps to pay out funds held in trust as soon as practicable once the legal services are complete. The basic principle here is don't leave funds sitting in trust when your legal services are at an end, and don't let your clients use your trust account as their bank account. At this point, someone will invariably ask, Tina, what does legal services mean? The expression legal services is not defined in the Law Society rules in Part 3, Division 7, nor in Division 11. So lawyers must use their professional judgment to determine whether the services requested of them are legal services, and if they are uncertain, they should seek professional advice. For example, if a client wishes to deposit funds into your trust account only for the purpose of paying bills such as rent and car lease payments each month, those are not legal services. The practice of law is defined in Section 1 of the Legal Profession Act. The provision of legal services thus relates to the provision of services that fall within the definition of practice of law. Let's do a quick quiz to see if you understand Rule 3-58.1. Which of these scenarios comply with Rule 3-58.1? You will need to carefully listen to the facts for each scenario as you consider the rule. Two sisters, Chrissy and Alicia, are both lawyers. They work out of a character home they remodeled in Kelowna. They each operate their own law firm, but have a space sharing arrangement that is compliant with the code rules. Chrissy is in the process of opening a trust account, but she has received a $2,500 retainer already. She knows that the Law Society rules require her to deposit trust funds as soon as practicable into a trust account. Since Alicia has a trust account, Chrissy deposits her retainer funds into Alicia's trust account. The following week, the funds are moved from Alicia's trust account to Chrissy's trust account. In the second scenario, Jenny has a law practice in Port Alberni. She has recently met the Law Society's requirements to act as a mediator and an arbitrator and will add these services to her practice. Jenny is worried about getting paid after the mediation or arbitration, so she is requesting retainers commensurate with the services to be provided. She deposits the retainer funds into her pooled trust account. In the third scenario, Anna is a senior lawyer representing a client in a criminal matter and expects legal services to total approximately $75,000. The client gives Anna a bank draft for $1.8 million, advising her that he will likely need legal services again in 2 or 3 years. When the file is complete, Anna bills the client $75,000 and moves the remaining funds into a separate interest-bearing trust account to earn interest for the client. In the last scenario, Jane is representing a non-resident in a corporate matter that will last several months. Jane has known the client since they were 6 years old and has represented him in 2 other matters. The client complains to Jane that he is having difficulties opening a bank account in Canada. Jane tells the client to wire the funds into her pooled trust account for the time being. Which scenario complies with Rule 3-58.1? The answer is Jenny. While acting as a mediator or arbitrator is by itself not the practice of law, Rule 3-58.1 sub 3 permits a lawyer to put retainers for services such as mediator, arbitrator, or parenting coordinator into a lawyer's trust account. This means the scenarios involving Chrissy, Alicia, Anna, and Jane are not in compliance with Rule 358.1. In the first scenario, Alicia is not in compliance because the rule requires the funds deposited into her trust account to be directly related to the legal services she provides. Instead, the funds in Alicia's trust account are for Chrissy's legal services. Anna is also not in compliance because the additional funds provided by the client are not directly related to the legal services she has been retained to provide. Furthermore, the remaining funds should have been removed from trust after legal services are complete, instead of being kept in a separate interest-bearing trust account. Lastly, Jane is not in compliance with Rule 3-58.1 because although she is providing legal services, the funds she is handling are not directly related to those legal services. Now, let's take a look at withdrawals from trust. Which of these scenarios comply with Rule 3-58.1? Again, listen to the facts. Steve is a real estate lawyer who acts for an executor for the sale of the deceased's property. The sale completes and the sale proceeds are deposited into Steve's pooled trust account. A week later, on the client's instructions, Steve withdraws the funds via a bank draft. The bank draft is made payable to another law firm that acts for the executor regarding the deceased's estate. In the second scenario, Mike represents a client in a litigation matter. The litigation completes and settlement proceeds of $25,000 are deposited into Mike's trust account. The client is going to counseling for substance abuse and requests that Mike send him $1,000 per month to help with cash flow. Mike sets up a $1,000 wire transfer to be made from his trust account to his client's account on the first of every month for 25 months. In the third scenario, John represents an individual who wants to purchase a small sporting goods store. The client provides a personal check for $650,000 made out to the lawyer in trust. John deposits the funds into his trust account. After several months of negotiations, the deal collapses and John issues a trust check to a foreign company that is owned by the client upon the client's request. In the last scenario, Jeremy represents an elderly client in the sale of the client's house. Due to language issues, Jeremy took instructions from the client's friend who has a power of attorney. Jeremy issued 2 trust checks. Half of the sale proceeds were wired to the client's bank account, and the other half was wired to the client's daughter in Toronto, who is purchasing her first house. Which scenario complies with Rule 3-58.1? The correct answer is Steve. Mike, John, and Jeremy did not comply with Rule 3-58.1 as they all provided banking services to their clients. In Mike's scenario, the rule required him to pay out trust money on completion of legal services. Mike should have paid the entire $25,000 to his client. John was also not in compliance because he returned funds to a company that is unrelated to the transaction. Rule 358.1 requires funds being deposited into and funds withdrawn from trust be directly related to legal services provided. The payment to the client's company is not part of the legal services John is providing. John should have returned the funds to the client. Lastly, similar to John, Jeremy wired half of the sale proceeds to the client's daughter, who was not involved in the transaction. Now, let's turn to a case study involving a BC lawyer. The disciplinary advisory that I referred to earlier, Lawyers Are Gatekeepers, discusses the Gurney decision. We will use this decision for our case study. Donald Gurney was a lawyer practicing in BC. Between May and November of 2013, the lawyer used their trust account to receive and disperse a total of over $25 million for a client. Gurney's fees were based on a percentage of the funds received and dispersed through the trust account. In this case, exactly 0.1%. The lawyer did not provide any substantive legal services in connection with the funds. The transactions did not require the use of a lawyer's trust account. And Gurney did not make reasonable inquiries about the circumstances related to the funds despite the red flags. All of the transactions dealt with offshore lenders to a new client. And Gurney's practice did not involve unsecured commercial lending. The hearing panel found that the lawyer committed professional misconduct by failing to make reasonable inquiries in the face of a sea of red flags. The results were the panel found Gurney to have committed professional misconduct. The panel ordered the lawyer to serve a 6-month suspension. Gurney was ordered to pay $25,845 to the Law Society, the amount that they had received as fees, so that the lawyer did not profit financially from the misconduct. And conditions on the use of a trust account were imposed. You can see that there were several risk factors involving legal services, the geographic location, and the client. Under legal services, substantial legal services were not provided, yet Gurney collected $25,000 as a service fee. The lawyer also did not have a background in offshore banking. Under geographic location, Gurney accepted over $25 million from foreign jurisdictions. Under client, it was the first time the lawyer was dealing with the parties. Gurney did not know where the money came from, who the lenders were, and what the funds were for. Our third topic today is cash. I will go through when you can accept cash, when you cannot accept cash, and what to do if you find yourself with cash you cannot handle. But before that, I want you to keep in mind that even if the no cash rule permit you to take your client's cash, you cannot accept cash that may have been obtained or derived from criminal acts. Barbara will discuss source of money in detail later in this presentation. In 2004, the Law Society introduced what has commonly been referred to as the no cash rule to ensure lawyers do not help criminals facilitate money laundering. As I discussed earlier, it's difficult for criminals to put their dirty cash into the financial system without it being traced back to them. They may seek to use a lawyer's trust account to clean the dirty funds. The no cash rule is quite simple. A lawyer must not accept an aggregate amount of cash of more than $7,500 for any one client matter. There are some limited exceptions to the $7,500 limit, such as cash for payment of a lawyer's professional fees for legal services. However, there's no exemption for taking any amount of dirty money. If someone wants to pay you in cash, you should be making inquiries. Why do they want to pay in cash? What is the source of the cash? And remember, you don't have to accept cash. You can have a no cash policy. Our next slide is a simple flowchart to help you understand the cash handling requirements. Remember the $7,500 threshold as a starting place. If you will receive more than $7,500, you must look at whether one of the exemptions to the dollar limit would apply. The most common exemption to the threshold amount is in Subrule 4, cash for professional fees, disbursements, and expenses, assuming there are no suspicious circumstances. In addition, Subrule 2 provides that Rule 3-59 does not apply at all if the lawyer receives cash in connection with the provision of legal services in 4 instances. Number 1, the cash is from a peace officer, law enforcement agency, or other agent of the Crown acting in an official capacity. Number 2, pursuant to the order of a court or other tribunal for the release to the lawyer or the lawyer's client of cash that has been seized by a peace officer, law enforcement agency, or other agent of the Crown acting in an official capacity. Number 3, the cash is to pay a fine, penalty, or bail. And fourth, the cash is from a financial institution or public body. The terms financial institution and public body are defined in Rule 3-53. If any of these exemptions apply, you are permitted to accept the cash beyond the $7,500 threshold. Sometimes lawyers inadvertently receive cash when they are not allowed. For example, your client may show up at your office and hand you cash. In this scenario, you would have received the cash, but you have not yet accepted it. Another instance of receiving cash is your client going to your bank and giving their cash to the teller to put into your trust bank account. We have even had lawyers tell us that their client slipped an envelope of cash under the lawyer's door after hours. These are all instances where the lawyer has received cash. Accepting the cash, however, means the lawyer has made use of the cash. You may have received cash, but you do not have to accept it, and you should not accept it unless you are permitted to by the rule. It's important to understand the difference between receiving and accepting cash, because if you haven't accepted the cash, there's still a way to stop the flow of cash into the financial system. Rule 3-59 sub 6 says that a lawyer that receives cash but is not permitted to accept it must 1. Make no use of the cash, 2. Return the cash to the payer immediately, and 3. Make a written report to the executive director within 7 days of receipt of the cash. So let's go back to the example in the previous slide. Let's say your client goes to the bank and gives $65,000 in cash to the teller and asks the teller to deposit the funds into your pool trust account. You are a diligent lawyer and follow up with the bank and the client about the sudden influx of money. You discover the money the client deposited was made in cash. While you receive the cash, you know you cannot accept it because it is for the purchase of a property. You immediately return the cash to the payer and write a report to the executive director. The rules were amended in July of 2019 so that if you accept an aggregate in cash of more than $7,500, you must make any refund in cash. So how do you actually refund cash if the cash already made its way into your bank account? The lawyer must physically go to the financial institution and withdraw cash. The rules do not permit you to issue a trust check payable to cash or bearer. We suggest that you contact your bank to have them set the cash aside. Branches do not always keep large amounts of cash in their vaults. Secondly, you should ask your client to meet you at the bank so you can immediately return the cash. Bring your cash receipt book so you can issue a cash receipt for the refund of cash. Have the client sign the receipt. To recap, if you need to refund money, how you refund it depends on whether you accepted an aggregate more than $7,500 in cash for the client matter. If so, you will need to make the entire refund in cash. A common question we get asked is, but Tina, if the cash is already deposited at the bank, I've helped launder the funds. Even if I withdraw cash, it won't be the same bills that were deposited. Think back to earlier in this presentation when we talked about the first step in money laundering. The criminal is attempting to put money obtained from criminal proceeds into the financial system. If you return cash back to your client, they will have to come up with another way of getting the cash into the financial intermediary. Returning the exact same bills you received in the first place isn't possible since it was already deposited. However, our concern isn't with fake currency. Understanding how to properly handle cash is important. Let's go through 3 examples. This is cash example number 1. The client gives the lawyer $10,000 cash for a retainer. If you read Rule 359 or go back to the flow chart, you will see that cash greater than $7,500 for professional fees is permitted. If there's nothing suspicious, the lawyer may receive and accept these funds. The lawyer performs legal services for the client and charges the client $9,500. The remaining $500 has to be returned to the client. Since the lawyer accepted more than $7,500 in cash, the refund of $500 must be made in cash. In the second example, the client brings in $7,500 cash as a retainer. The lawyer provides legal services and charges the client $2,000. There is a $5,500 remaining in trust. Since the lawyer did not accept more than $7,500 in cash, the lawyer must make the refund by trust check, electronic funds transfer, or bank draft. Rule 3-64.1 sets out how to withdraw funds from trust by electronic funds transfer. In this final example, the client gives the lawyer $10,000 cash and $10,000 check. So the lawyer is holding a $20,000 retainer in her trust account. The lawyer performs legal services and charges the client $11,000. How should the lawyer return the remaining $9,000 to the client? Let's see if you can figure out what the lawyer must do. Number 1, the lawyer must refund $9,000 via trust check. Option number 2, the lawyer must refund $4,500 via cash and $4,500 via trust check. Number 3, the lawyer must refund $9,000 via cash. Or number 4, lawyer can refund $9,000 via trust check, cash, or electronic funds transfer. Since the lawyer accepted more than $7,500 cash, the lawyer must refund the entire $9,000 in cash. Therefore, the correct answer is number 3. If you have any questions regarding the cash rules, we encourage you to contact the Trust Assurance Department for guidance. Rule 3-70 is a related rule that requires a lawyer to maintain a cash receipt book of duplicate receipts. The practice must issue a cash receipt each time cash is received or refunded, and the receipt must contain the date the cash was received, the amount of cash received, the client's name, the payer's name, because sometimes the person giving you the cash may not be your client, the client file number, and 2 signatures, the signature of the person giving the cash and the signature of the person receiving the cash. Having 2 signatures on the cash receipt serves as proof that the transaction occurred as documented. Imagine receiving $10,000 cash one day from your client, but then at a later date, your client claims that he gave you $20,000. A cash receipt signed by the payer and payee helps keep transactions traceable. Lastly, if the receipt is later modified, the date of the modification must also be noted. This sometimes occurs when the person accepting the money does not have the client file number handy and needs to add it to the cash receipt later. Here are some common cash errors you should look out for. In estate files, this executor may sell the deceased's car for $13,000 in cash and then deposit the cash to the lawyer's trust account. In another instance, the executor discovers $50,000 in cash hidden in various locations in the deceased's house and deposits the cash to the lawyer's trust account. In real estate files, the client might make direct deposits of cash in aggregate of more than $7,500 to the lawyer's trust account, or multiple purchasers or family members each deposit small amounts of cash that add to more than $7,500. In the estate and real estate examples that I just gave, the cash wasn't for a retainer and didn't fall under any of the other exemptions in Rule 3-59. Cash errors can also occur in other types of files, so beware of a changing purpose. For example, a lawyer receives a $14,000 retainer that was paid in cash, and it is still in trust. The client is now required to pay child or spousal support in the amount of $14,000. If you use the retainer funds to pay the child or spousal support, you would breach the cash rules. Secondly, do your due diligence with refunds. Let's say the client matter has been ongoing for multiple years. The client has received several checks, bank drafts, and more than $7,500 in cash over time for a retainer. If the matter is complete and funds need to be returned to the client, the lawyer, without thinking, may issue a trust check in error. This is incorrect because he accepted an aggregate of more than $7,500 cash for this client matter, so any refund must be made in cash. Lastly, beware of direct cash deposits in aggregate amounts. A client might make direct deposits of cash in various increments directly to the law firm's trust account. If the law firm did not verify the form of funds deposited and keep track, the cash deposited may exceed the $7,500 threshold. Here are some final reminders on cash. On the annual trust report, the Law Society requires lawyers to report if the lawyer or law firm has received cash in aggregate of greater than $7,500. Accurate reporting on the trust report is necessary to ensure the integrity of the trust assurance program. Noncompliance with the cash rule is very serious. Here are 3 tips to help you avoid running into trouble. Implement a no cash rule with your clients. Put up a sign in your reception area and add a paragraph in your retainer agreement so clients are aware. Make sure staff are reminded on a regular basis of their obligations towards cash. Number 2, review your bank accounts on a daily basis and follow up on any deposits that were not made by the practice. Funds that have been deposited into your accounts directly may be in the form of cash. If so, the cash rules would apply. Let me give you an example. There was a BC lawyer acting for a purchaser. The BC lawyer asked the client to provide $10,000 to complete the purchase. The client told the lawyer that he was in another province and would deposit the funds directly into the lawyer's trust account. The lawyer proceeded with the transaction and the file was closed. During a compliance audit, the auditor discovered the $10,000 that the client deposited at the bank was in the form of cash. In other words, the client went to the teller, gave the teller $10,000 cash, and had the bank put the money into the lawyer's trust account. Even though the lawyer or law firm did not physically handle the cash rules still apply. As such, the lawyer was not permitted to accept the funds and should have returned the cash to the client. The third tip is to ask your bank to not allow third-party deposits into your account, but we find that safeguard weak and cannot be relied upon. If you improperly handle cash, you may be assisting criminals with money laundering. Within the Division 7 accounting rules, 2 other rules play a role in helping lawyers comply with their anti-money laundering efforts. One is Rule 368 requires lawyers to record the source and form of funds received in the Trust Book of Entry, or the Trust Account Ledger. Second, Rule 369 requires lawyers to record the source of funds received in the General Book of Original Entry, also known as the General Accounts Ledger. There is sometimes confusion over what this means. For Rule 368 and 369, the source of funds received is the name of the actual individual or organization that provided the funds. It's not sufficient for you to record the source of funds received as client or excess deposit. If you receive a bank draft, sometimes the financial institution will indicate the payer's name. If they do not, the lawyer will have to make inquiries to determine the source of funds. For Rule 3-68, the form of funds received is the method by which the lawyer received the funds. This can include checks, cash, wires, e-transfers, and electronic funds transfers. Remember, it does not include direct deposit because a direct deposit can mean many different methods. Please ensure that you record both the source of funds received and the form of funds received in the Trust Book of Entry. I do want to caution our viewers that the source of funds I discussed just now relates to the accounting rules in Division 7. In Division 11, the client identification and verification rules, Lawyers are required to obtain and record the source of money, which is a key component in the client verification process. Next, I'm going to turn this over to Barbara, who will go through the client identification and verification requirements.
Hello, I'm Barbara. If you haven't taken a break yet, you may want to take one before starting part 4 of this course, a new subject. In this part, we will discuss the client identification and verification rules, also commonly referred to as the CIV rules. I'll probably say that a lot. We'll also talk about some BC Code rules, and which are further elements of the Law Society's AML measures. AML means anti-money laundering. The professional responsibility obligations in the CIV rules and other AML rules are meant to help reduce the risk of lawyers unwittingly facilitating dishonest or illegal activity, including money laundering, and to help protect the public. Public confidence in the legal profession may be eroded if a lawyer acts irresponsibly or if there is the appearance of impropriety. You are aware that criminals may try to use you as a gateway to facilitate money laundering and other illegal activity. They may also try to use other professionals that come in contact with you and your clients as well. You and other members of the public could end up as victims. Let's talk about your clients. Many clients will have some awareness of money laundering due to the various BC government reports and publicity, some of which we reference at the outset of our program. Sophisticated, legitimate clients may provide you with retainer letters with outside counsel terms requiring you to comply with applicable sanctions laws, comply with anti-bribery laws, and conduct periodic background checks on your staff even. Some clients, on the other hand, may not understand why you require certain information and complain. You may need to explain that you have professional obligations that you must fulfill. You can explain that these obligations are part of the regulation of the legal profession by the Law Society. The Law Society and lawyers must support the fight against money laundering and terrorist financing in order to protect the public. The CIV rules are in Part 3, Division 11 of the Law Society rules. Those are Rules 3-98 to Rule 3-110. They have their own standalone division, Division 11. The CIV rules came into effect at the end of 2008, and there have been some amendments from time to time since then. With limited exceptions, the CIV rules apply to a lawyer retained by a client to provide legal services. Note that being retained isn't limited to a money retainer. It's broader, as in to counsel or to act. For example, if you provide legal services for free, but there is a financial transaction, you must identify and verify the client's identity unless there is an applicable exception. For example, you may initiate a debt claim for someone that results in a financial transaction, the payment of settlement money, but you didn't charge for your legal services. Nevertheless, you were retained to provide these legal services, even though you didn't receive a money retainer. The CIV rules have some similarities to the obligations of designated individuals and entities that are required to report to FINTRAC, pursuant to the Proceeds of Crime, Money Laundering, Terrorist Financing Act. Those reporting entities include accountants, BC notaries, casinos, specific financial entities, life insurance companies, money service businesses, real estate developers, real estate brokers or sales representatives, securities dealers, and as of October 11th, 2024, the mortgage sector, comprised of mortgage administrators, mortgage brokers, and mortgage lenders. The government has plans to include title insurers and reporting entities too under the legislation. So depending on when you watch this program, title insurance insurers may be included in the regime. As you know, lawyers do not submit reports to FINTRAC on their clients. Lawyers are not subject to those reporting requirements of the legislation as a result of the Supreme Court of Canada's decision in 2015, the Attorney General of Canada against the Federation of Law Societies of Canada. I would like to draw your attention to Rule 3-99, sub 1.1. This rule is significant as it focuses our attention on the overall picture of your AML obligations. It emphasizes your overarching obligations to know the client, understand the client's financial dealings in relation to the retainer, and manage any risks arising from the professional business relationship with the client. Knowing the client would include obtaining identity information and verification of identity when there's a financial transaction. Understanding the client's financial dealings in relation to the retainer would include, in addition to understanding the deal and the transactions, obtaining information about the client's source of money for the transactions. Managing risks is more than ticking a box with the client's name, address, phone number, and getting ID. It's not just a simple checklist. Managing risks would include being on the lookout for red flags, making reasonable inquiries, following up on suspicions or doubts, monitoring the business relationship, and depending on the circumstances, either not acting for the client at all or withdrawing if you're already acting. You must always be vigilant and use your professional judgment to ensure that you are not complicit in a crime. Money laundering and terrorist financing can be hard to detect sometimes, and of course doesn't appear with any kind of announcement. I want to emphasize the importance of a lawyer's BC Code obligations as well. The term competent lawyer is defined in Code Rule 3.1-1. It includes conscientiously applying intellectual capacity, judgment, and deliberation to all functions. When assessing risk, use your professional judgment about how much information and supporting documents you may need in the circumstances. While some technical exemptions to the CIB rules may exist in particular cases, remember your overall obligations to know your client, manage risks, and understand the client's financial dealings. If something doesn't feel right, verify ID and make enough inquiries about the client, the financial transaction, and the source of money to satisfy yourself whether you can act or continue to act. You have a duty to make inquiries if there are suspicious circumstances and to make a record of the results of your inquiries. Large amounts of cash are generally a red flag. Also, international electronic funds transfers are a known money laundering, terrorist financing typology, especially when funds are moved in and out of high-risk jurisdictions. If someone wants to provide you with cash, it's important to know the purpose as it affects the cash limit restrictions for Rule 3-59 in Division 7 that Tina spoke about, as well as it being a red flag. Conduct your due diligence. Ask the client why they want to provide cash and where it came from. Does it make sense? Assess the risks of acting for the client. You don't have to take cash and shouldn't if there's anything suspicious about it. Also, if you take cash for a retainer, the amount should be commensurate with the services to be provided. In other words, don't accept a $15,000 cash retainer for a $4,000 service. That could be offside Rule 3-58.1 that Tina covered earlier as well. The money that you accept and trust must be directly related to the legal services to be provided. In addition to the Law Society rules and the BC Code rules, the Criminal Code applies to lawyers as it applies to all people. Laundering the proceeds of crime is commonly referred to as money laundering. If a lawyer acts for a client laundering money from illegal activities, no solicitor-client privilege applies. I've set out the criminal code offense of laundering the proceeds of crime that appears in section 462.31 sub 1. You will see that the section refers to the commission of a designated offense. Criminal lawyers will be familiar with the term, but for everyone else, if you wish, you can read the definition of a designated offense in section 462.3. The money laundering section was amended effective June 21, 2019 to include a recklessness provision for mens rea. However, further amendments to the money laundering provision were included in Bill C-59. This bill received royal assent on June 20th, 2024. The amendments to the money laundering provision, section 462.31, come into effect 90 days after royal assent. 3 new subsections, sub 1.1 to 1.3, were added. As of the date of this course, there has been very little discussion about these subsections. There is potential for a significant impact on lawyers and their clients because subsection 1.1, headed prosecution, states, subject to subsection 1.3, in a prosecution for an offense under subsection 1, which you see on the screen, it is not necessary for the prosecutor to prove that the accused knew, believed they knew, or was reckless as to the specific nature of the designated offense. And it goes further. Subsection 1.1, headed inference, states, subject to, actually that's 1.2, subsection 1.2, headed inference, states, subject to subsection 1.3, the court may infer that an accused had the knowledge or belief or demonstrated the recklessness referred to in subsection 1 if it is satisfied, given the circumstances of the offense, that the manner in which the accused dealt with the property or its proceeds is markedly unusual, or the accused dealings are inconsistent with lawful activities typical of the sector in which they take place, including business activities. You should also be aware of how to screen for clients who may be on a government watch list so that you can determine if you can provide the legal services. You can perform your own manual searches or use products available on the commercial market. See the Public Safety Canada website for information on currently listed terrorist entities. The definition of an entity includes a person, group, trust, partnership, or fund, or an unincorporated association or organization. The Global Affairs Canada website maintains information on the sanctions imposed by Canada under the Special Economic Measures Act, the United Nations Act, and the Justice for Victims of Corrupt Foreign Officials Act. Countries, individuals, and entities are named. As you'll recall, the Justice for Victims of Corrupt Foreign Officials Act, often referred to as Canada's Magnitsky Law, is named after the Russian tax lawyer Sergei Magnitsky. As a preamble to the legislation notes, he uncovered a large tax fraud, was detained without trial, was tortured, and consequently died in a Moscow prison. The Magnitsky Law prohibits persons in Canada and Canadians outside of Canada from facilitating, directly or indirectly, any financial transaction with certain named foreign nationals. Okay, let's return to the Law Society's CIV rules. First, I'll provide an overview. You'll recall the big picture rule that I mentioned earlier, Rule 3-99, sub 1.1, to know the client, understand the client's financial dealings in relation to the retainer, and to manage any risks arising from the relationship. In this next part, I'll talk about the 6 requirements in the CIB rules set out in this slide. Well, the first 3 are in this slide. And the following slide have the other 3. Note that the words in quotations are defined terms, defined in Rule 3-98. The 6 broad client requirements are to identify the client when you're retained to provide legal services. That's in Rule 3-100. There's some limited exceptions. Secondly, to verify the client's identity if there's a financial transaction. Again, there are some limited exceptions. Third, obtain from the client and record with the applicable date information about the source of money if there's a financial transaction. There are some limited exceptions to this too. 4, maintain and retain records. 5, withdraw if you know or ought to know that you would be assisting in fraud or other illegal conduct. When you're thinking about withdrawing due to concerns about dishonesty, crime, or fraud, remember that in addition to Rule 3-109 and the Law Society rules, to consider also the BC Code rules, and in particular, Code Rules 3.2-7 and 3.2-8 and the commentary. Don't overlook the commentary to the code rules. As stated in the code's introduction, and determining one's professional obligations, lawyers should be guided in their conduct equally by the language in the rules, commentary, and appendices. Also, mandatory statements have equal force wherever they appear in the code. So a mandatory statement could appear in the commentary. Monitor your lawyer-client business relationship while retained in respect of a financial transaction. You are expected to keep a dated record of the measures taken and the information obtained. How and when you monitor the client will depend on the facts. If you act on a real estate conveyance for a retired couple selling the home that they've lived in for 30 years and the closing is in 1 month, there would be less monitoring than acting for a company buying multiple commercial properties over nearly 2 years. So we'll have more on this later. These are just highlights. Take note that the CIB rules have 12 defined terms in Rule 3-98. You will want to pay attention to the definitions. They're important. Some terms are broadly defined and they're different from common usage. While all of the terms are important, I suggest you pay particular attention to the broadly defined terms, financial transaction, money, and client. Also, knowing where to find the terms, Rule 3-98, can help you comply with the rules and for some clients save effort and expense. For example, if your client falls within the definition of a financial institution, public body, or a reporting issuer, because of an exemption in the rules, while you would identify these 3 types of clients, that is a financial institution, a public body, or a reporting issuer, you aren't required to verify the identity of such clients, nor are you obliged to obtain information about the client's source of money for a financial transaction. In addition, you don't have to verify the identity of the individual instructing you on behalf of these 3 types of clients. This, of course, assumes there's nothing suspicious. For example, it has happened where representatives of financial institutions have been complicit in illegal activity, so you can't always completely let your guard down. For example, New York regulators fined a big bank $150 million over ignoring red flags regarding an accused sex trafficker. This slide sets out the broad definition of financial transaction. Notice that it means the receipt, payment, or transfer of money on behalf of a client, or giving instructions on behalf of a client in respect of the receipt, payment, or transfer of money. With respect to giving instructions on behalf of a client for a financial transaction, you'll need to use your judgment based on the context. When you give instructions, it means that you direct the movement of the money for the client. So for example, my client, ABC Company, has instructed that you wire the settlement funds to its account number 123 at XYZ Financial Institution. Giving instructions on a client's behalf to someone is different than giving confidential advice to a client. So you may give advice to a client about the tax consequences of a share transfer. Simply providing this confidential advice to a client about possible tax consequences of taking a certain course of action is not giving instructions on behalf of the client. Now you know there's a wide definition of the term financial transaction, but also please note that there is a wide definition of money. And the term money is referred to in the definition of financial transaction. So a definition within a definition. Obviously, money includes cash and currency, but it also includes securities, negotiable instruments, or other financial instruments in any form that indicate a person's title or right to or interest in them, and electronic transfer of deposits at financial institutions. Notice that there is no requirement for money to be deposited into a lawyer's trust account in order for there to be a financial transaction. Why is this important? Because if there is a financial transaction, it triggers both the verification of identity requirements and the source of money obligations. I set out an example in the slide. If a lawyer gives instructions on a client's behalf in respect of a share transfer, because of the definition of money, that could be a financial transaction triggering verification of identity and the source of money obligations. Although there are some limited exceptions to verification and the source of money obligations set out in Rule 3-101, most of the time when a financial transaction occurs, verification is required. Also keep in mind that if money is coming into your trust account for a financial transaction, the money is also eventually going to go out of your trust account. That is two financial transactions, deposit and withdrawal. If you are looking to rely on an exemption, there must be an exemption for both the deposits and the withdrawals from trust. An example is in a later slide dealing with exemptions. If you are unsure whether there is a financial transaction, I suggest that you err on the side of caution and remember your overall obligations to know your client, understand the client's financial dealings in relation to the retainer, and manage any risks. The client. So who is the client? The word client is widely defined in Rule 3-98. A client, for the purpose of the CIV rules, is wider than the BC Code rules. It's a different definition. So this wide definition says a client is another party that a lawyer's client represents or acts for, and an individual who instructs the lawyer on behalf of a client for a financial transaction. I suggest that you determine who your client is right away, not only to check for conflicts before acting, but also in order to consider the application of the CIV rules. Often it's quite obvious who the client is, and at other times it might not be immediately apparent. You'll need to determine, for the purpose of the CIV rules, if another person is directing or instructing or has authority to direct or instruct the client, as a principal instructs an agent. If the client is representing or acting for someone else, then you would take steps to identify, and if required, to verify the identity of the person who is pulling the strings. I'd like to particularly mention a power of attorney. Based on the definition of client, verify the donor's identity, called the ADL in the Power of Attorney Act in BC, as well as the attorney's identity. It helps protect against the fraudulent use of a power of attorney. If, for example, the adult has executed a power of attorney, allowing an attorney to sign land transfer documents while the donor will purportedly be in Hawaii, verify the donor's identity before the financial transaction is completed. You've already heard me use the terms identification and verification. Now I'd like to talk about those terms. Keep firmly in mind that identification and verification are two separate but related concepts in the CIV process. Understanding the difference will save you confusion and compliance issues. Identification is essentially the act of obtaining basic information from the client that is set out in Rule 3-100. There are very few exemptions to this requirement. Almost all lawyers will automatically obtain this information from the client to open a new file. You can ask the client for this information verbally in a form, email, video conference, however you're communicating. You're not required to view the client's identity document to identify the client. Under most circumstances, if you are retained to provide legal services, you will need to identify your client under Rule 3-100. There'll be more on this later. Verification, on the other hand, is required if there is a financial transaction, with limited exceptions. Importantly, if verification is triggered by a financial transaction, it also triggers a source of money obligations. The main requirements are set out in Rule 3-102. Verification is the process of confirming that the client is who they say they are and to gain an understanding of the persons involved. For example, your client tells you that his name is John Smith. How do you know you're really dealing with John Smith? If you use the government-issued ID method of verification, you might ask John to show you his BC driver's license or Canadian passport when you meet with him, and then retain a copy of every document you look at to verify his identity. If there isn't a financial transaction and there's nothing suspicious, then verification is usually not necessary. We'll cover more on verification later. So now we'll look at the rules in some greater detail. This slide lists the information that lawyers must obtain when identifying an individual under Rule 3-100. So the information can be easily obtained and recorded by asking the client during a phone conversation or in an email, or the client filling out a form. And the information is set out in Rule 3-100 that you must obtain. Pay attention to the occupation, and I'd like to provide some guidance about this. No vague descriptions. So businessmen, self-employed, unemployed, and retired are not really occupations. Obtain more descriptive information, such as retired BC lawyer, unemployed teacher. For other vague descriptions that a client might say, such as investor, consultant, entrepreneur, manager, promoter, obtain information that identifies the nature of the individual's work and the industry involved. Record the information with the applicable date and retain it for the period set out in Rule 3-107. Limited exceptions to the requirement to identify a client are set out in Rule 3-99, sub 2. If you are an in-house counsel employed by an organization, such as me being an employee of the Law Society, or act in circumstances where there is no financial transaction as part of a duty counsel program sponsored by a nonprofit, or provide pro bono summary advice where there is no financial transaction, you'll want to read about the exceptions. Whether you are identifying an individual or an organization, you will need to retain the information in accordance with Rule 3-107. 3-107 includes time periods for retention. This slide shows a list of the information that lawyers must obtain when identifying an organization. This information can also easily be obtained and recorded during a phone conversation with the instructing individual or using a form, etc. Lawyers don't have to obtain and record the general nature of the business or activity for the 3 exempted organizations. For example, if your client is a financial institution, as defined, you must identify the client, but you don't have to obtain and record the information set out in the last 2 bullets on this slide. So let's review some key points about identifying your client. You need to obtain the information set out in Rule 3-100 and record it with the applicable date. You can easily get it over the phone, in a form, or by email. You don't have to physically meet with the client to identify the client. 2, remember that the client is widely defined for Division 11 purposes. 3, when you identify a client that is in an organization, you must also obtain information about the instructing individual. 4, you don't have to obtain documents from the client for their identification. But if you do obtain documents, they must be retained in accordance with Rule 3-107 for the longer of the duration of the relationship and as long as it's necessary for the purpose of providing services to the client, or at least 6 years following completion of the lawyer's work. Rule 3-107 sets out the record-keeping requirements. Once you obtain and record the identification information of an individual, you're not required to subsequently obtain and record the information about the same individual again, unless you have reason to believe the information has changed. See Rule 3-100 sub 1B in that regard. If a previous client approaches you for a new matter, and you've not had contact with the client for some time, it would be prudent to review the identification information you have in your file with your client to ensure your information is accurate. That's a natural thing to do for any office. You get asked that. Do we have your current phone number, address, etc.? Now we are switching over from the simple process of identifying a client to the verification of a client's identity. This is where you're verifying the legitimacy of the client's identity using one of the methods in the Rule 3-102. Know when you must verify a client's identity. Rule 3-102 sub 1 requires you to verify the client's identity when you provide legal services in respect of a financial transaction. We've already gone over the meaning of a financial transaction. Remember, that's defined in Rule 3-98. Keep in mind that a financial transaction also triggers the obligation to obtain and record information from the client about the client's source of money for the financial transaction. We'll cover the source of money obligations later. There are also timing requirements for verification of identity that we'll go over later. The timing can differ depending on who the client is. Before we talk about the methods of verifying a client's identity, let's consider who can verify the individual's identity. You, the lawyer, can verify your client's identity, obviously. However, another member or employee of your firm, wherever located, may fulfill your responsibility to verify the client's identity on your behalf. Alternatively, you may use an agent, either through a new verification by the agent or by relying on a previous verification of the individual by the agent. You, of course, are ultimately responsible to ensure that your client's identity is verified if required. For BC lawyers who were verifying their client's identity before March 2024, You will remember that you had to use an agent to verify an individual's identity if the individual client was outside of Canada and you or someone from your firm were unable to physically meet with that client. Note that effective March 8th, 2024, Rule 3-104 sub 5 was rescinded. So now a lawyer is no longer required to use an agent for verification if the individual client is outside of Canada. There are FAQs, meaning frequently asked questions, on the Client ID and Verification Resources webpage about using an agent to verify a client's identity if you'd like to look at them later. There will be links to a checklist and a sample agreement with an agent as well. Timing. At the time that you provide legal services in respect of a financial transaction, you must verify the identity of a client who is an individual. See Rule 3-105 sub 1 and the definition of client in this regard. Note that this timing includes the timing for verification of the individual instructing you on behalf of an organization client as well. If you have verified an individual's identity previously, you aren't required to verify them again unless you have reason to believe that the information or accuracy of it has changed. Best practice would be to review and update the client's information periodically. Consider that at the time you see your dentist, doctor, accountant, or other professional, they often check to see whether your information has changed. Sometimes you will have verified an individual's identity using valid, authentic, and current government-issued photo ID, but the ID expires while you're still acting. Assuming there's nothing suspicious, you may decide it's reasonable to continue to rely on the previous verification of the individual's identity. This assumes that the client's information is the same and that the driver's license has simply expired. This topic is discussed in the FAQs on the Law Society website. Now we'll turn to the methods for verification of an individual's identity. There are 4 main methods set out in Rule 3-102 sub 2 to verify an individual's identity. Remember that this includes verification of the identity of an individual who is instructing you on behalf of an organization as well. The 4 methods are: number 1, the government-issued photo ID method with a physical meeting. In this case, you're not required to use the rules. You're not required under the rules to use authentication technology. 2, the government-issued photo ID method with a virtual meeting. In the case of a virtual meeting, reliable authentication technology is required under the rules. 3, the credit file method, and in this case, no physical meeting is required. And 4, the dual process method. In this case, no physical meeting is required. So the only time that you need a physical meeting is method 1, where you're using a government-issued photo ID method and you're not using authentication technology. So you can use any one of the 4 methods used in Rule 3-102 to verify an individual, provided that the documents and the information are valid, authentic, and current. I'll talk a little more about each of the 4 methods in turn. However, note that for more information, you can look at the FAQs later for such questions as: what is client verification? What are the methods to verify an individual's identity? What about the source of money? There's lots of FAQs to assist you. Rule 3-102 sub 2A little Roman numeral I sets out the government-issued photo ID method of verifying an individual's identity. This rule is applicable if you physically meet with the client, and it also applies if you have a virtual meeting, but an additional sub-rule applies for virtual meetings. The process and requirements to verify an individual's identity in a physical meeting differ from verifying an individual's identity in a virtual meeting. However, in both situations, Whether physical or virtual, you would use the individual's valid, authentic, and current photo ID issued by the Government of Canada, a province or territory, or a foreign government. An ID issued by a municipality is not acceptable. An individual might produce their driver's license, a combined BC driver's license and services card, a BC ID card, or a passport. A BC services card with a photo ID is used to help access health services and government services. It replaced the CARE card in 2013. As you will recall, the CARE card did not have a photo ID. ICBC describes the common features of licenses and ID cards on its website. Information is also included in the CIV FAQs. The Government of Canada describes the features of Canadian passports online, and often you can review the features of identity documents of other provinces, territories, and foreign governments online as well. To use the photo ID method when meeting with the client physically, the client would produce their physical, valid, authentic, and current government-issued photo ID in your physical presence. If you verify a client's identity in a physical meeting, you can use authentication technology as an additional measure to determine that the individual's ID is genuine if you want to do so and the client agrees. If you have a virtual meeting with the client, instead of a physical meeting, you must use reliable authentication technology to confirm that the individual's ID is genuine and confirm that the name and photo of your client are those of the individual in the ID. A video conference with a scan or electronic image of the ID before and during the meeting is not sufficient to comply with the rule. More information about the government-issued photo ID method is included in the CIV FAQs. The last section of this course, the resources section, will provide more information about that. Subrule 2.1 was added to Rule 3-102 on March 8th, 2024. This is where authentication technology comes in. The subrule says, for the purposes of subrule 2A(i), that's the government-issued photo ID method of verification of an individual's identity, an electronic image of a document issued by the Government of Canada, a province or a territory, or a foreign government other than a municipal government may be treated as authentic, provided the lawyer has used reliable technology to confirm that the identification document is genuine and has confirmed that the name and photograph are those of the individual in the identification document. For their virtual verification, the individual will provide the front and back of their government-issued photo ID for authentication. Unless your firm has reliable authentication technology itself, you would use an outside third-party authentication technology vendor. You would ask your client to connect with them. The client would provide their ID and a selfie to the vendor following the vendor's process. The individual would generally take a photo of the front and back of their ID and a photo of themselves, that is, a selfie. The vendor's authentication system would use facial recognition technology to compare the individual's features in their selfie to the individual's photo in their government-issued photo ID and conduct a liveness test. In addition to matching the photos of the faces in the ID and the selfie, the vendor would use technology to analyze the person's ID, looking at security features such as barcodes, holograms, magnetic strips, watermarks, and embedded electronic chips. The vendor's technology would compare the individual's ID against known characteristics that the ID should have, such as a required space between characters, raised lettering, design, and other features such as logos and symbols like the BC Bear. The vendor would issue you a report as to whether the authentication passed or failed. The report should include the front and back of the individual's photo ID. Likely it would include the selfie too. As part of the virtual verification process, you will have a video conference with the client that confirms that the individual is the same individual featured in the authenticated ID. See the practice resource, Using Video Conferencing Technology, Guidance, and Professional Obligations, for video conferencing information such as selecting a service provider, best practices for video conferencing, and some relevant code rules and tips to reduce the risk of a negligence claim. Read the Law Society's practice resource, Guidance for Virtual Verification of Your Client's Identity Using Government-Issued Photo ID and Technology. Guidance includes steps to take in relation to virtual verification, resources, risk and benefits considerations, and some information about vendors who offer authentication technology services. This information is also included in the resource section of this course, the final section. Lawyers may find it attractive that some vendors use technology to assess thousands of government-issued photo IDs issued in jurisdictions outside of Canada. Examples include passports, driver's licenses, and national identity cards issued in such places as Australia, Bermuda, Brazil, Bulgaria, Congo, Croatia, Germany, India, Israel, Hong Kong, the UK, and the United States, and very many other countries. The Law Society does not authorize or endorse vendors of reliable authentication technology. There is no approved list. A list of some of the many vendors offering their services is included in the guidance resource. This isn't an endorsement. There are other vendors too. Some may charge nearly twice as much as others and may require more information to be provided to them by the client than other vendors. The price may vary with your requirements and the vendor's processes. Keep in mind that you don't have to use the same vendor every time you verify an individual's identity. With some, you can simply pay as you go. Keep in mind that the vendors currently are largely unregulated, so you will want to vet them and be comfortable that they have reliable authentication technology and also be comfortable with their insurance coverage, services, standards, and procedures regarding confidentiality, privacy, and security, and other features important to you. Some vendors require employees to have criminal records check. Consider obtaining advice from your tech professionals about reliable technology vendors. However, I recommend that a lawyer be involved too, because the tech professionals may not be familiar with a lawyer's obligations in the code, the Law Society rules, and relevant legislation. There are some other things to think about when you consider vendors of authentication technology. For example, consider the client experience. Does the vendor overreach? What I mean is, does the vendor ask the client for more information than the Law Society rules require for the government-issued photo ID method? If yes, this is likely much more costly for the client and, of course, more intrusive. If you use the government-issued photo ID method, Rule 3-102 does not require that you additionally use the credit file method or the dual process method, or that the client provide their banking information to the vendor. Rule 3-102 requires that you use one of the methods if verification is required for a financial transaction. You will also want to consider if the vendor's process is easy to use. Does the vendor require the client to use an app? Some clients may be concerned about adding the vendor's app to their device. They don't all ask for an app. Who will see the client's confidential data? Just you and the client? Is the vendor going to see it? And if the vendor sees it, do the vendor's employees undergo criminal records checks? Also, importantly, consider, does the vendor retain the client's data? Are they retaining the front and back of the driver's license? If so, why are they retaining it? And if so, if they're retaining it, for how long? Where? You're the one that needs to, retain it. So just find out. I think the client will want to know, you'll want to know. Will the vendor's report provide you with the front and back of the individual's authenticated ID for your records? You need that. Will they provide the selfie too? What is the reliability of the vendor's identity verification testing? Does the reliability differ if the vendor is assessing ID from jurisdictions outside of Canada? For example, a California driver's license, a Turkish driver's license? Now let's do a quiz to see how well you know the CIV rules so far. There are 6 statements. Which statement or statements are correct? So the first one is that a lawyer must always verify an individual's identity. 2, verification of identity requires 2 government-issued photo IDs. 3, verification of identity requires 1 government-issued photo ID and banking information. 4, when verifying an organization, verification of the instructing individual of the organization isn't required. 5, all of the 4 statements are correct. 6, none of the above are correct. Give you a moment here. The correct answer is the last one. None of the statements are correct. So let's go back and figure out why. So in the first one, a lawyer must verify an individual's identity if there's a financial transaction that requires it. So that's wrong. The second one, I've received calls from lawyers and law firm staff who are somehow under the mistaken impression that the rules require 2 IDs for real estate transactions. So that's not the Law Society rules. The Law Society, if you use the government issued photo ID method, requires 1 ID. The third one, if you use the government issued photo ID method, whether physical or virtual, you are not additionally required to obtain the client's banking information as part of the verification process. The next one, you must always verify the identity of the organization's instructing individual if there's a financial transaction, unless an exemption applies. And of course, the next one, all of the 4 statements are correct or wrong. So none of these statements are correct. Okay, we'll go to the next slide. So we've covered the first 2 methods of verifying an individual's identity, the government issued photo ID method with a physical meeting and the government issued photo ID method with a virtual meeting using reliable authentication technology. So we'll turn to the third method, the credit file method, for verification of an individual's identity. The credit file method is described in Rule 3-102, sub A, sub little Roman numeral 2. This method can be used for individuals who have valid and current credit file information located in Canada. It's not a credit assessment, so it's not an assessment of the person's credit score and their ability to pay your account, for example. To use this method, the information in the individual's credit file must have been in existence for at least 3 years. So the method wouldn't work for a potential client who's been in Canada for less than 3 years. Some BC lawyers use this method as it doesn't require a physical meeting with an individual to verify their identity. And once they're set up to verify the identity this way, it's quick. The setting up process with the credit bureau, however, takes some time. For example, it could take a week or so to get the system in place. You can obtain the information from one of the Canadian credit bureaus or their authorized agent, but they are not. So Equifax Canada and TransUnion Canada are the two Canadian credit bureaus. If someone is telling you that they are an agent, you might actually want to check with Equifax Canada or TransUnion to make sure that's correct. You must match the name, address, and date of birth that the individual provided to you with the credit bureau information and create a record that includes the individual's full name, the length of their credit file history, which can't be less than 3 years, their credit file or reference number, the credit bureau's name, and the date that you searched to obtain the information. If you investigate these services, determine that the service that you're considering would reliably verify that the individual is who they say they are. It is not simply a matter of a person with a certain name, address, and birth date having a credit score. You're not looking to get their credit score. You're looking to verify their identity. So obviously there's a cost to this service, and be prepared for putting in some effort at the front end to get set up with a credit bureau. The credit bureau will want to be satisfied that who you are before providing this service to you. You may consider adding additional screening services, such as global watch list services, PEPs, that's politically exposed persons, close associates and family members of PEPs, et cetera, that the credit bureaus offer. And there's other resources that offer such additional services as well. The dual process method is the fourth method of verifying an individual's identity set out in Rule 3-102. Like with the credit file method, you do not have to physically meet with the individual client to verify the client's identity when using the dual process method. You would obtain information from two different independent and reliable sources to verify the individual's ID and create a record. You would use information from 2 out of the 3 categories set out in the rule. Information that contains the individual's name and address is a category. Information that contains the individual's name and date of birth, another category. And the final category, information that contains the individual's name and confirms that the individual has a deposit account or a credit card or other loan amount with a financial institution. You can't have 2 sources of information from the same category. For example, one source could provide you with the information in A, that is a source that could provide you with information with the individual's name and address, and a second source could provide you with the information in B, information with the individual's name and date of birth, or you could obtain A and C information. You couldn't, for example, use category A twice. Note that you must use 2 different categories and that the information referred to must be from 2 different reliable sources. So you can't use the same big bank as a source for more than one category. What is a reliable source of information for the dual process method? A reliable source is one that is well known, considered reputable, and one that you trust. Examples of a reliable source are the federal, territorial, and municipal levels of government, crown corporations, financial institutions, and utility providers. Neither you, your client, nor your client's friend or relative or an agent would be considered a reliable source. I've listed some examples of documents that you could obtain from a reliable source on this slide. You could also obtain information from the reliable source that was not in a document, information that you could confirm in writing with the reliable source. More examples and information are included in the Law Society's FAQs. As I mentioned previously, this will be available in the resources section at the end. Okay, the next subject is using an agent to verify ID. Using an agent to verify the client's identity is an option that's available to you in which you don't have to physically meet with the client. You or someone from your firm may not be able to verify the client's identity for some reason, but there may be someone suitable to act on your behalf to verify the client's identity using one of the methods in Rule 3-102. Usually the agent is using the government issued photo ID method and meeting with the client physically. That's the most common thing that has happened. Your agent should be someone reputable and who will diligently carry out the work within the time that you require it. Using another regulated professional to be your agent would be prudent, but it's not currently a requirement. You and your agent must have a written agreement or arrangement in writing for this purpose. Remember that the agent is your agent, not the client's agent. There's a sample agreement in the CIB checklist about using an agent. You must not rely on the information obtained by your agent unless you obtain all of the information obtained by the agent under your agreement or arrangement with the agent, and you're satisfied that the information is valid and current and the agent verified an identity in accordance with Rule 3-102. There are FAQs for using an agent to verify a client's identity, including an FAQ about relying on an agent's own previous verification of the same individual. This takes us to our next slide about relying on an agent's previous verification. So I'll talk briefly about relying on a previous verification that an agent may have performed to verify an individual's identity in the past. So when they verified them, they weren't doing it for you back then. They were doing it for themselves or someone else. So Rule 3-104 sub 7 provides that a lawyer may rely on an agent's previous verification of an individual client if the agent was, at the time of the verification, A, acting in the agent's own capacity, whether or not the agent was acting under this rule, or B, acting as an agent under an agreement or arrangement in writing entered into with another lawyer required under this division, that's Division 11, to verify the identity of the client. An example of an agent acting in their own capacity could be a lawyer, accountant, or notary who's governed by a regulator and who had to verify the individual's identity to provide legal services. You still must have an agreement or arrangement in writing with the agent if you wish to rely on the agent's previous verification of an individual in accordance with the verification method in Rule 3-102. In follow-up, the verification information that you receive from the agent should match the information that the individual client provided to you when you obtain their basic identification information for 3-100. You must satisfy yourself that the information is valid, authentic and unaltered, and current, not expired. Note that the date that you receive the agent's confirmation of verification, as this relates to whether the information is recent and the timing within which verification must take place with respect to the financial transaction. This is set out in Rule 3-105. Verifying a minor's identity. Verifying the identity of an individual that is a minor is covered in Law Society Rule 3-102 as well. If the minor is younger than 12, you must verify the identity of the individual's parent or guardian. If the minor is 12 or older, but younger than 15, you must obtain information from a reliable source that contains the name and address of the individual's parent or guardian and confirm that the address matches the individual's address. If the minor is 15 or older, verify the minor's identity by referring to information from a reliable source that contains the name and address of their parent or guardian and verifies that the address is that of the minor. Although Rule 3-102 doesn't require it, depending on the nature of the retainer, it could be prudent to obtain information or records that confirm the minor's relationship with the parent or guardian, such as a birth certificate or adoption order. Now we'll move on from verifying an individual to verifying an organization. Keep in mind that an organization is a widely defined term in Rule 3-98. For example, an organization could be a company, a society, or an unincorporated association. The definition is on the slide. Also pay attention to the definition of client if you're required to verify the identity of an organization. This is important because you must verify the identity of the individual instructing you on an organization client's behalf, in addition to verifying the identity of the organization itself. And if the client organization represents or acts on behalf of another party in relation to obtaining legal services from you, you must also verify the identity of that other party. I suggest that you take reasonable measures to determine if your client is acting on behalf of someone else, maybe someone who doesn't want their name to appear openly. Note the timing difference between verifying the identity of the organization itself and the timing for verifying the instructing individual or individuals. You have 30 days, if needed, to obtain and record all of the information required regarding the organization. However, that extra 30 days doesn't pertain to the instructing individual. You must verify the identity of the instructing individual at the time you provide legal services in respect to the financial transaction. If you are required to verify an organization client's identity for providing legal services in respect of a financial transaction, you must verify the organization's identity promptly and in any event within 30 days. Rule 3-102 sub 2 deals with both registered organizations and unregistered organizations. Subrule 2B deals with registered organizations. For many organizations, such as companies and societies, you'll be able to perform searches in government registries. Subrule 2C deals with documents that you could obtain to confirm the existence of an unregistered organization, such as an unincorporated association. If you're required to verify an organization, you must also follow the steps required by Rule 3-103 to identify the directors. Note that this is about identification, not verification. As part of verifying an organization, you must obtain and record, with the applicable date, all of the directors' names. Securities dealers exempted. You must take reasonable measures to confirm the accuracy of the information and keep a record with the applicable dates of the measures taken to confirm the accuracy. A company search would normally suffice as a reasonable measure to obtain and record the directors' names. If you're dealing with an organization that has directors, you likely already obtained the directors' names when you did a company search in a government registry for the purposes of Rule 3-102. Note that it is not a requirement to verify the identity of the directors. It's a requirement to identify them. You only have to verify the identity of the individual or individuals who are instructing you. Now, the instructing individual could happen to be a director, and in that case, you would be verifying a director's identity. Rule 3-103 also requires that you must make reasonable efforts to obtain, and if obtained, record with the applicable date, the names and addresses of all persons who own directly or indirectly 25% or more of the organization or its shares. This doesn't mean verify their identity. You would verify their identity if they were instructing you on the organization's behalf. You would also make reasonable efforts to obtain and record, if there's a trust involved, the names and addresses of all trustees and all known beneficiaries and settlers of the trust, and information identifying ownership, control, and structure of the organization. As with the case of directors discussed in the previous slide, you must also take reasonable measures to confirm the accuracy of the information obtained regarding the shareholders, owners, trustees, all known beneficiaries, and settlers of the trust. You're required to keep a record with the applicable dates of all of your efforts and measures taken. Depending on the context and jurisdiction, government registry searches may exist to obtain information about the owners, shareholders, trustees, unknown beneficiaries, and settlers of a trust. If registry searches are not available, consider other sources such as minute books, shareholders agreements, trust deeds, partnership agreements, and open source searches. You could ask the client to sign a document confirming the accuracy of beneficial ownership information if you want. As you know, a legal owner of a property or asset may not always be the same as the beneficial owner. Concerns about beneficial ownership emerge in relation to establishing entities, various financial transactions, financings, and trusts. When lawyers verify identity, the Law Society wants lawyers to drill down until they get to an actual individual person. Getting to the ultimate beneficial owner may not be straightforward. It can be difficult to identify the ultimate owner, particularly when various parties partially own one another. Circular ownership structures are sometimes used to mask an organization's actual ownership. Concerns about beneficial ownership have been highlighted in federal reports and BC government commission reports about money laundering, including in 2 chapters of the Cullen Commission's final report, chapters 23 and 24, and have been reflected in changes to legislation. BC's expert panel, chaired by Professor Maureen Maloney, recognized the disclosure of beneficial ownership as the single most important measure that can be taken to combat money laundering. Be aware that criminals may try to conceal their identity using companies and trusts and other arrangements to facilitate money laundering and tax evasions. You are expected to try to obtain the identity of the individuals who are the actual owners and controllers of organizations. The ultimate beneficial owner of an organization cannot be another organization. It must be the actual individual or individuals who are the owners or who are in control of the organization. Search through as many levels of information as it is necessary to find an actual individuals. And in BC, we now have LOTA, the Land Ownership Transparency Act registry. As you know, the idea is that the registry would hold records of the individuals behind various ownership structures, such as trusts, partners, companies, of a particular parcel of land. We also have the Central Securities Register. Also, all BC companies must have a Central Securities Register that's set out in the Business Corporations Act. At the federal level, CBCA corporations must prepare and maintain at their registered office or other designated place a register of individuals with significant control, that is, beneficial owners. If you're not able to obtain the information required in Rule 3-103, sub 1, concerning the directors, shareholders, so on, or as required in sub-rule 2 of Rule 3-103, to confirm the accuracy of that information, in continuing your due diligence, you must take the steps set out in sub-rule 4. You must take reasonable measures to ascertain the most senior managing officer's identity. In the case of a partnership, the most senior managing officer can be one of the partners. In the case of a trust, the senior managing officer of a trust would be the trustee, the person authorized to administer or execute on the trust. In the case of a corporation, society, or other organization, the senior managing officer may be the CEO, president, CFO, COO, or someone who performs any of those functions. Note that the rule doesn't require you to verify the identity of the most senior managing officer by using one of the verification methods for individuals in Rule 3-102, unless, of course, that is the individual instructing you. You must determine whether the client's information in respect of its activities, in respect of its source of money to be used in the financial transaction, and the client's instructions in respect of the transaction are consistent with the purpose of the retainer and the information that you've obtained by the client that's required by the rule. You would treat such a client as high risk. You must assess whether there is a risk that you may be assisting in or encouraging fraud or other illegal conduct. If you act with a client, you would consider Rule 3-109 and the Code Rules 3.2-7, 3.2-8, and the withdrawal rule in 3.7-7. You would keep a record with the applicable date of the results of your assessment and determination. If you were unsuccessful in identifying the most senior managing officer and so on, you would record the measures that you took to obtain the information, the date that you took them, and the reason why you were unsuccessful. I referred to Code Rule 3.2-7 previously, but I want to highlight it here. It says that a lawyer must not engage in any activity that the lawyer knows or ought to know assists in or encourages any dishonesty, crime, or fraud. I'd like to stress some of the commentaries to the rule. Please take the time to read them and think about them if you haven't done so recently. Commentary 1 says that a lawyer should be on guard against becoming the tool or dupe of an unscrupulous client or of others, whether or not associated with the unscrupulous client. And commentary 2 says that a lawyer should be alert to and avoid unwittingly becoming involved with a client engaged in criminal activities, such as mortgage fraud or money laundering. Commentary 2 sets out some of the transactions for which lawyers commonly provide services, such as establishing business entities, preparing loan documents, and real estate transactions. Commentary 3 refers to a lawyer's duty to make inquiries to obtain information. Take special note of Commentary 3, please. Before accepting a retainer or during a retainer, if you have suspicions or doubts about whether you might be assisting a client in any dishonesty, crime, or fraud, you should make reasonable inquiries to obtain information about the client and about the subject matter and objectives of the retainer. Note that these inquiries should include making reasonable inquiries to verify the legal or beneficial ownership of property and business entities and who has control of business entities, and to clarify the nature and purpose of a complex or unusual transaction where the nature and purpose are not clear. Commentary 3.1 requires that you should also make inquiries of a client who seeks to use your trust account without requiring any substantial legal services or promises unrealistic returns on their investment to third parties who place money in trust with you or are being invited to do so. And 3.2 says that you should make a record of these inquiries. This includes recording the results of your inquiries. Look for any circumstances that ought to raise your suspicions that you might be assisting in any dishonesty, crime, and fraud. Even one suspicious circumstance could be sufficient to trigger your duty to make further inquiries. What if you are an employee of an organization, or if you are retained by an organization and the organization has acted or is acting dishonestly, criminally, or fraudulently? In addition to your obligations in Code Rule 3.2-7 that we just went over, Rule 3.2-8 sets out what you must further do. It involves up-the-ladder reporting, starting with the person from whom you take instructions and the chief legal officer, or both the chief legal officer and the CEO. If the organization continues with or intends to pursue the wrongful conduct, you must withdraw from acting on the matter. In some cases, withdrawal could mean that a lawyer would resign from their position or relationship overall and not simply withdraw on the particular matter. It could be for all matters. Okay, let's do another poll question to see how well you know the CIB rules. Which statement is correct? And be forewarned, it's tricky. So the first one is that a BC lawyer doesn't need to verify the identity of a BC lawyer client. 2, verification can be completed by obtaining the client's credit report. 3, verification is exempt for children under 2. 4, when using an agent for verification, lawyers must retain a copy of the agent's agreement between the client and the agent. 5, all of the above are correct. Or 6, none of the above statements are correct. So the correct answer is the last one, number 6. So the first statement is false because you're required to verify a client's identity if there's a financial transaction, unless there's an applicable exemption. A lawyer is not an exempt client. And 2, verification can be completed by obtaining the client's credit report. That's a tricky one. It's false because you need to use the information in the individual's credit file, not their credit report. Verification is not exempt for a child under 2. And in number 4, the reason this is wrong is because the agreement is between the lawyer and the agent, not the client and the agent. All right, we'll move on here. So we finished with the verification of individuals and of organizations, and now we're turning to another requirement in the CIB rules, obtaining information about the source of money. When you provide legal services in respect of a financial transaction, if you're required to verify a client's identity, you have a concomitant duty to obtain information about the client's source of money for the transaction. This is an important part of your risk assessment to determine whether you will act for a client or continue to act. You may be able to easily verify a client's identity. You may meet with the client, and the client may present you with a perfectly valid original and current driver's license or passport with a photo that matches their description. But what about the money for the $5 million transaction? What's the client's story? Where's the money coming from? How was it generated? As we know, dirty money may come from such activities as human trafficking, illegal arms sales, stock manipulation, illegal wildlife trade, fraud, or illegal drugs, and you obviously don't want to be used to facilitate any financial transactions in relation to such money or schemes. I want to stress that obtaining information about the source of money for a financial transaction is part of the Part 3 Division 11 rules, that is part of the CIB rules. This obligation in Division 11 is separate, but related to the Division 7 trust accounting rules that you heard about earlier from Tina. If you want to, Read about the source of money in Division 11 as compared to some of the Division 11 trust accounting requirements. You could look at my articles in the winter 2019 and fall 2019 Ventures Bulletins. They're entitled New Client Verification and Source of Money Requirements in the in those bulletins. These articles are easily found on the Client ID and Verification webpage. And as Tina mentioned earlier, we'll have a resources section at the end of our presentation. Note that if you look at older articles, they won't have the recent rule changes to Law Society rules. So if it refers to an old rule like that you must use an agent to verify identity if the client's outside of Canada, that's changed, of course. The requirement to obtain and record with the applicable date information about the source of money from your client in respect of a financial transaction appears 3 times in the Division 11 rules. So first, it appears in Rule 3-102(1)(a). That's the overall requirement. When you provide legal service in respect of a financial transaction, unless there's an applicable exemption, you must obtain from the client and record information about the source of money. Secondly, as we discussed in the context of organizations, when you're having problems obtaining or confirming the accuracy of information required in Rule 3-103, it comes up. And finally, a source of money comes up again in the monitoring rule, Rule 3-110. We'll get to the monitoring rule later. You likely want to obtain the source of money information early in the retainer and recognize that you may ask about the source of money more than once, depending on such variables as the number of transactions, the time frame, and any shift in the purpose of the retainer and the information received. The information on this slide and the next one is included in resources that are available in the last segment of this presentation. Relevant information to obtain is 1, the payer's full name, occupation, and contact information. So the payer could be your client, or it might be a third party. It could be the client's mother. 2, the relationship of the payer to the client. So again, the payer may be the client, or it could be a third party. 3, the date that you received money from the payer. 4, the economic activity or action that generated the money. So it might be settlement funds from a wrongful dismissal claim or a motor vehicle accident. It might be money from a bank loan for a conveyance. It might be savings from their salary, or it could be an inheritance, for example. Next, you want to record the form in which you receive the money. So like check, bank draft, wire. Next, the full name and address of all financial institutions or other entities through which the payer processed or transmitted the money to you. And at the end, any other information that's relevant. Lawyers have asked if they're required to obtain documents to support a client's explanation regarding the economic activity or action that generated the source of money and retain copies. In the absence of suspicious circumstances, you may accept a client's explanation regarding the economic activity or action that generated their source of money, such as inheritance, savings from salary, life insurance proceeds, etc., without obtaining copies of the documents or retaining them to support the explanation. In a presentation given by Dr. Peter German, KC, on money laundering in the real estate sector of BC, he found it interesting that many properties were owned by students, homemakers, or unemployed individuals. If someone in these circumstances is coming to you as a potential buyer client, you have an obligation to understand the circumstance. Ask, where's the money coming from? Is it a legitimate source, or is this person being used as a straw buyer? Where there are suspicious circumstances or red flags, you should make further inquiries and assess the risk of participating in a financial transaction for a client. Verifying your client's identity and obtaining information about the source of money isn't simply ticking off boxes in a checklist, online or otherwise. You must make inquiries and apply your professional judgment. You have an obligation not to ignore suspicious circumstances. Unless you're satisfied that you're not assisting a client in doing something dishonest or illegal, you must not act or continue to act. Remember Code Rule 3.2-7. You'll want to check out the source of money FAQs on the client ID and verification webpage later. The next few slides set out examples of some red flags regarding client risks and transaction risks that would inspire you to proceed with caution and make inquiries in order to determine whether it would be appropriate to act. Here are some examples of red flags in relation to clients. In the first example, the client seeks to use your trust account without requiring any substantial legal services. The client may even ask you to open up an account for them, suggesting that you be their attorney under a power of attorney for that purpose. They may say that they are outside of Canada and the bank won't let them open an account unless they physically come into the bank. Another example is where the client's been de-risked by a financial institution, so their accounts have been closed. A third example is that it's unclear why the client chose you considering your profile and geographic location. Are you known to be competent to practice in the area? For example, securities. Are you and the client in different locations? Why did the client choose you? Doesn't make sense. Watch out for phony referrals. Also, if the clients frequently change counsel for unknown reasons, that's a red flag. A client may change counsel due to a falling out, a health reason, or some other good reason, but oftentimes if there's a change of counsel more than once, it's because the previous lawyers determined that they should not act. Here's some more examples of client risk. The client uses aliases without explanation. The client evades requests to verify their identity, or they're very familiar with client verification. The client's a new offshore client who has a large transaction. The transaction involves third parties or intermediaries, including in giving instructions. The client offers to pay high fees that aren't in keeping with the legal services being provided. The client wants to pay with cash. And here are yet some more examples of client risks. The client's age or capacity is unusual for the transaction. I mentioned this before. So say a 20-year-old student or an unemployed person is buying a $3 million condo, that's a red flag. An organizational client that uses free email like Hotmail or Gmail or Yahoo, not very professional. And if they don't have any reliable internet presence, that's a red flag. The client provides false or counterfeit documents. Think of that, client giving you false or counterfeit documents and they want to get a bank loan and they want you to act. Big red flag. The client is secretive or evasive about themselves, others, and the transaction. They may mention a vague business in another country. The client has a cash-intensive business. The client's in a rush and doesn't care much about details. Next are some red flags regarding transaction risks. So it's a high-value transaction without any financing. So they're buying a $5 million house, no financing. The client is evasive about the source of money for the transaction, or their explanation just raises more questions. Or third-party funding would be provided by somebody with no apparent connection to the transaction. Money's coming from somewhere, say they're buying the $5 million house, somebody else is giving them the money and there's no mortgage. The transaction doesn't make any commercial sense. They want a private mortgage registered with no funds provided, or you may be asked to act in litigation involving private lending. Funds are to be sent to or received from a high-risk jurisdiction. What is a high-risk jurisdiction? You can find information about high-risk jurisdictions on the Government of Canada, FinTrack, and the FATF websites. FATF is the Financial Action Task Force. High-risk jurisdictions generally have significant deficiencies in their regimes to counter money laundering and terrorist financing. They may also be known for being a location for which funds or support are provided to terrorist organizations. High-risk jurisdictions may be known to have significant levels of corruption or other criminal activity. In any case involving a high-risk jurisdiction, enhanced due diligence is required to protect against money laundering and terrorist financing. Here's some more red flags. A client wants you to pay money to a third party whose relationship to the client or the transaction is unknown, or it raises more questions. The client uses multiple bank accounts or foreign accounts without good reason. The client repays mortgages repeatedly well before the initially agreed maturity date with no logical explanation. And if you're asked to act on a private real estate sale where there's no realtor involved, there may be no money exchange, only a change of ownership on title. That's a red flag. There may also be red flags when clients want you to create corporate structures. So for example, the client wants you to incorporate a company, but doesn't want you to provide any other legal services, just incorporate the company. Or they don't have a good reason for incorporating. It's very vague. They may want complex structures, again, for no apparent reason. They don't have an existing business or any business plan. The client is a director of companies in multiple jurisdictions, but is unable to provide much information about the companies. And the client instructing you won't be the real owner of the companies. They'll be beneficial ownership. So for some information about this, you could read the article, Forming Companies and Other Structures, Managing the Risk in the Spring 2021 Ventures Bulletin. Next, we'll look at a case study about some clients' unexplained source of wealth. Here's the background. So a couple recently immigrated to Canada from a country that poses a geographical risk. They retained a BC lawyer to assist with the purchase of a large residential property and to set up a company. They paid for the home without any financing. The couple separated soon after moving to Canada. However, despite separating, they continued to buy and develop several residential properties together, usually without financing, through their joint company. At one point, the ex-husband transferred his interest in the company to a real estate agent that the clients used for the purchases, only to transfer the interest back a short time later. The clients didn't have any employment or business interests in Canada beyond real estate investing. The ex-husband was an extensive gambler and required income from the properties to pay for these activities. So what are some red flags? They were from a high-risk country. They had an unexplained source of wealth for purchasing properties. They purchased several residential properties without financing over a short period. They had a potential marriage of convenience as they separated soon after entering Canada. There was an unusual transfer of the client husband's interest in the couple's company to a realtor, only to be transferred back to the husband quickly for no apparent reason. The husband was heavily involved in gambling. So what can you do as a lawyer? In addition to obtaining information about the source of money for the transactions, when clients are from a high-risk country and they have wealth of mysterious origin, you should conduct further inquiries and record the results of the inquiries. The inquiries would include requesting documents about the source of money. The additional red flags, extensive gambling, possible marriage of convenience, large purchases without financing, also indicate a need for caution and inquiries. Unless you're satisfied that the money for the transactions is not from the proceeds of crime and you're not assisting the clients in doing something dishonest or illegal, you must not act or continue to act. Now we'll turn to the monitoring rule 3-110. Rule 3-110 requires you to periodically monitor your professional business relationship with a client while retained in respect of a financial transaction. This includes long-standing clients. You must periodically assess whether the information that you have obtained about the client's information about their activities, the source of money, defined in Rule 3-98, used in the financial transaction, and the client's instructions are consistent with the purpose of your retainer. Risk assessment includes periodically monitoring the client's information about the source of money used in the financial transaction and assessing whether there's a risk that you may be assisting in or encouraging dishonesty, fraud, crime, or other illegal conduct. You may also need to consider Rule 3-109 and BC Code Rules 3.2-7 and 3.2-8 that we talked about earlier. You must keep a record with the applicable dates of the measures that you've taken to comply with the monitoring rule and the client information that you've obtained. And you would retain the record for the period required in Rule 3-107. The frequency of your monitoring and what information should be recorded will depend on what's reasonable in each case. For example, if you act for a local seller of their $500,000 condominium and the matter closes in 3 weeks, the monitoring rule may have limited or no applicability. You would have assessed the risks of acting at the outset of the retainer and during the course of the very short file. The file from start to finish may have ended in less than a month. On the other hand, if you act for a buyer of multiple properties over 20 months, you should periodically monitor the file and make inquiries about the source of money for the various financial transactions. You are required to apply your professional judgment to assess risks in any given circumstance. There are monitoring FAQs on the webpage. So I've mentioned Rule 3-107 before, and that it's about record keeping and retention of the information that you must obtain and record, and the documents obtained or produced for the purposes of the rules. You can keep these records in a machine readable or electronic form if you can readily produce a paper copy. And you'll note the rule sets out the period of time for which you must retain the records, at least 6 years following completion of the work for which you were retained. You may also wish to review Law Society Rules 10-3 and 10-4 as they apply to records related to your practice. Rule 10-3 has to do with storage of records, their custody, control and production. And Rule 10-4 has to do with the security of records. Now, some exemptions. In Rule 3-101, there are some exemptions from the requirements in Rules 3-102 to 3-106, including the requirements to verify a client's identity and to obtain information about the client's source of money. If an exemption applies, you would still identify the client in accordance with Rule 3-100. So if an exemption applies, also that doesn't mean that if there are red flags or suspicious circumstances that you are exempted from making reasonable inquiries, making a record, and determining whether it's appropriate to act. Now I'll discuss some of the particular exemptions. The first exemption involves the client itself. I briefly mentioned this before. If your client is a financial institution, public body, or reporting issuer, all defined terms in 3-98, you are not required to verify the identity of the client. A financial institution, a public body, and a reporting issuer, I just said that they're all defined terms. Okay. So you're also not required to verify the identity of the individual or individuals instructing you on behalf of any of these 3 types of clients. Further, you don't have to obtain money about these clients' source of money. So for example, if your client is a big bank and you take instruction from the big bank's representative, Anna, you wouldn't be required to verify the identity of the bank nor of Anna. Further, You would not be required to obtain information about the bank's source of money for the financial transaction. This is all qualified by saying that nothing is suspicious. As we know, employees of financial institutions have been found to be involved in money laundering. If there are red flags, you would consider your obligations under Rule 3-109 and the BC Code Rules 3.2-7 and 3.2-8. Here is another common Rule 3-101 exemption, probably the most common. When you receive money for a retainer or payment of your account for professional fees, disbursements, or expenses, those are obviously financial transactions. However, there is an exemption from the requirement to verify the client's identity and to obtain information about the source of money set out in Rule 3-101. As I said in relation to the previous slide about exempt clients, if an exemption applies, that doesn't mean that if there are red flags or suspicious circumstances that you're exempted from making reasonable inquiries, making a record, and determining whether it's appropriate to act in the circumstances or to receive the money. If you are considering an exemption in Rule 3-101 from your verification and source of money obligations, consider whether an exemption applies to both the money that you would be receiving in trust and also payment of money out of trust. Sometimes there is a Rule 3-101 exemption for receiving money in trust, but no exemption for paying money out. If there's no exemption from the payment of the money out of trust, the obligations in Rules 3-102 to 3-106 would still apply. For example, if there's a Rule 3-101 exemption, 3-101 exemption for the receipt of money from another BC's lawyer's trust account or from the trust account of another interjurisdictional lawyer. An interjurisdictional lawyer is a defined term, meaning a member of a governing body who is authorized to practice law in another Canadian jurisdiction. So it wouldn't take in, for example, a California lawyer. So, however, this exemption does not apply to the payment out of money. If you get money from an Ontario lawyer or a BC lawyer, there's an exemption for that money coming in from their trust account. But it doesn't exempt, there's no exemption for you paying that money out of the trust account. So if you be paying the money out, your obligations would apply as usual, unless there is an exemption for the payment out in 3-101. I'd like to take a minute to say something to you about referrals by other lawyers. You're not required to repeat compliance with Rules 3-100 to 3-106. If another BC lawyer or interjurisdictional lawyer engages you to provide legal services to the client as an agent or refers a matter to you for the provision of legal services. However, the other BC lawyer or interjurisdictional lawyer must have complied with Rules 3-100 or 3-106 or the equivalent provisions of a governing body in Canada. Here's some cautions. Make sure the referral is legitimate and that there are no suspicious circumstances that haven't been dealt with. There's no exemption from the requirement to manage risk and conduct due diligence. Sometimes a bad client will say they've been referred, but the lawyer actually never made a referral. Or the referral could have been, I don't do that kind of work, but Janet Lee does. You could see her. Explain to the client that you will need to confirm that the referring lawyer has complied with all of the relevant CIV requirements. Obtain copies of the information and documents from the referring lawyer and keep a dated record. There's no exemption from the umbrella rule 3-99 sub 1.1, 3-107 record keeping and retention, 3-109 criminal activity, 3-110 monitoring, or from the BC Code Rules. So next, the in-house counsel employee exemption. So Rule 3-100, as well as the verification rules, record keeping and monitoring, don't apply when a lawyer provides legal services to their employer. So I'll make an example of myself again. I'm a staff lawyer employed by the Law Society. As an employee, when I provide legal services to my employer, the Law Society, I'm not required to identify the Law Society, verify its identity, ask about its source of money for a financial transaction, maintain and retain records related to these things, nor do I have to monitor the Law Society in accordance with Rule 3-110. So what applies? As far as the Division 11 rules, 3-98 and 3-99 apply. 99 is where my exemption is, and Rule 3-109, of course, would apply. And of course, the code rules always apply. The duty counsel exemption. There's a special exemption from CIV rules for duty counsel. So if you provide legal services as part of a duty counsel program sponsored by a nonprofit organization and no financial transaction is involved, you would not be required to identify and verify or monitor such clients. The remaining CIV rules would apply. Pro bono summary advice. There's also a special exemption from some CIV rules in the case of providing pro bono summary advice. So same very as this previous slide, and as in the case of the duty counsel exemption, the remaining rules would apply: 3-98, 3-99, and Rule 3-109. If there was a financial transaction and no applicable exemption in Rule 3-101, you would still verify the client's identity. There's also a bail exemption if you pay or receive money for bail for your client. 4 important rules to be familiar with regarding dishonesty, fraud, or other legal conduct are set out on this slide. I've mentioned in the CIV rules, there's 3-109. So it provides in the course of obtaining the information required in Division 11 or at any time while retained by the client, if you know or ought to know that you are or would be assisting a client in fraud or other illegal conduct, you must withdraw. And then there's, of course, the code rules that we've talked about. And, they provide, like Code Rule 3.2-7 specifically addresses being alert to money laundering and provides some good examples. So I encourage you to read it. And 3.7-7 says, of course, that you must withdraw if a client persists in instructing you to act contrary to professional ethics, or if you're not competent to handle the matter. So let's do one last quiz. Quiz 7. Which statement or statements are correct? Rule 3-101 exempts obligations to verify identity and obtain source of money obligations. If there is a red flag, I should immediately withdraw. I am always exempt from verifying my client's identity if I act pro bono. Authentication technology is always required to verify government-issued photo ID. All of the above statements are correct. 2 of the above statements are correct. Let's see what is the answer. The correct answer is the first one. Rule 3-102 exempts the obligations to verify identity and to obtain source of money information. However, as we have stressed repeatedly, if there are red flags, you shouldn't simply rely on an exemption. You need to consider the context and make reasonable inquiries. This may include asking about the source of money and obtaining supporting documents to determine if you can act or continue to act. Here are some questions to ask yourself to help you think about your obligations. Who's the client? Remember the broad definition of client in Rule 3-98 and that for the purposes of verification, the individual who instructs you on behalf of an organization is also a client. What are the legal services? Is a client just trying to use your trust account without requiring any substantial legal services in relation to the money? What is the source of money? Does it make sense? Does the transaction make sense? Do I understand it? Do I have sufficient information to act for the client on this matter? Is there anything suspicious? Have I completed my due diligence? Do I need supporting documents? Can I properly receive money into trust? Pay it out. Remember that the funds deposited into and withdrawn from trusts must be directly related to the legal services that you are providing. Am I competent to act in this practice area? Consider getting advice if you're having difficulties. I've set out some further tips, a list of some best practices to protect you and your firm. They are: 1, read Law Society of BC and LIFT publications. Contact a practice advisor or trust auditor if you have questions. Keep your client information up to date. Ensure you obtain and record information for the underlying client as defined in Rule 3-98. Keep your beneficial ownership information up to date. Understand how your client makes their money and what their business does. Use sufficient measures to mitigate risks with higher risk clients. 7, identify the inherent risks and consider whether the client poses an increased risk. For example, the client was referred to you and you have limited knowledge of the client or the trustworthiness of the referral. The type of legal service. For example, the client wants you to set up a trust, but they have no real nexus to Canada. Consider the products and the delivery channels. Consider the geographic location of the client and the transactions. Are there countries known to have high corruption levels? Consider the client's characteristics. Are they a politically exposed person? Are they from another country? Source of payments risks. International wire transfers are an area of concern. Also virtual currency and cash. Yet more, if the client poses higher risk characteristics or you are uncomfortable, conduct more due diligence. Consider using third-party sources to confirm your client's business or operations. Use Google Maps or similar tools. Look at the client's location and the nature of its operations. I mean, is there really a business there? Consider visiting the client's place of business. Use a commercial name screening application to screen your clients. Consider screening all your new clients. Review your client's name against an official government list: law enforcement, regulatory sanctions, economic sanctions, and terrorists. And even more, be aware of and consider the legislation and regulations that may be relevant to a person or assets connected with the client's file. These 3 acts I mentioned before on cross-border payments and may raise particular risks. And going beyond, be alert and proactive by reading relevant resources such as government announcements regarding organized crime, money laundering and fraud, FinTrack news releases, and special bulletins and advisories. So now we're in our very last section. We're almost at an end here. And today's program provided you with a detailed overview of some of the Law Society's AML measures, the cash rules, the CIV rules, and some BC Code rules. There are many resources on the Law Society website to enhance your understanding of the rules and to manage risks. The next series of slides will refer to a number of online resources and people resources, all are accessible free of charge. So I'm not going to read out these resources, but just want to bring a few things to your attention. At the top of the list are the client identification verification rules. And you'll see that we have a client ID and verification resources webpage. You can get to the landing page where you'll find over 30 resources. So some of the key resources regarding CIV are included on this slide. You might like to read the top 10 tips and review the FAQs as a follow-up to the program. There's also a checklist available that you can edit and tailor to your law practice. The checklist is long, but you can shorten it and just tailor it to your practice and make it your own. And we've included the code rules on being a competent lawyer and the rules referred to previously about dishonesty and fraud. And we've listed a number of other resources here that are on the CIV webpage. And pay attention to the Law Society's discipline advisories. They're based on actual matters that came before the Law Society, and they advise lawyers of conduct that can lead to discipline. You can go to the discipline advisories landing page to see all of the advisories issued by the Law Society, but some advisories relevant to our presentation today include the ones on client ID and verification, country geographic risk, securities fraud, private lending, and lawyers are gatekeepers to their trust accounts. Here I've listed some decisions that you may care to read and follow up to this course. In the first one, Peltier, the lawyer, engaged in grave misconduct and was disbarred. The tribunal panel found that he was aiding and abetting his clients in securities fraud. The May decision involved builders' liens matters in which the lawyer failed to investigate evolving facts and make inquiries. He also failed to comply with client identification obligations. Kukalak involved real estate transactions that were objectively suspicious. A client was a known drug dealer. The lawyer failed to make reasonable inquiries. There were also issues with CIB and misappropriation. In Osei, over $2 million flowed through the lawyer's trust account when he did little or no legal work. There were several red flags and the lawyer failed to make reasonable inquiries. The Gregory decision is on appeal, so you would need to follow up on this. In this case, the client was profiled in a national news article that alleged that the client and an associate were laundering funds obtained from drugs in the real estate market. The tribunal found the lawyer had been retained to foreclose on a private mortgage without making reasonable inquiries to satisfy himself on an objective standard that the client wasn't seeking the lawyer's assistance to launder money or commit fraud. In Yen, the lawyer permitted over 10 million US and over 1 million Canadian to flow through her trust account without providing substantial legal services, making inquiries, and recording the results of the inquiries. There were numerous red flags. In Uzalak, there were a number of red flags, but the lawyer received and dispersed over $1 million through his trust account with respect to an investment scheme without making reasonable inquiries. The lawyer was suspended for 4 months. And the Gurney decision was covered earlier by Tina, resulting in a 6-month suspension.
If you visit the Trust Accounting resource page on our website, you will find a link to our free Trust Accounting webinar, which provides participants a chance to work through a trust reconciliation exercise, a link to our free Trust Accounting Regulatory Requirements webinar, the Trust Accounting Handbook, which explains what the trust rules require in plain language, and common forms, checklists, and templates to assist with complying with the Trust Accounting rules. For trust questions, the contact information for the Trust Assurance Department will be provided in the next slide. We encourage you to reach out to us with any questions you have about trust accounting. Auditors answer questions to ensure trust, general accounting, and cash standards are met. Here's our contact information. If you require guidance on client identification and verification, AML, fraud, or scams, Barbara is available by phone or email. Barbara and I thank you for your interest in AML and hope that you found this course educational. The information in this presentation is current to August 6, 2024, so viewers should refer to the Law Society's website for the most up-to-date rules and requirements.